Now, in Nigerian law, a higher court can stop proceedings in a lower court if the applicant shows special or exceptional circumstances. This is governed mainly by Section 6, subsection 6 of the 1999 Constitution, Judicial Powers. It gives courts the power to protect their jurisdiction and prevent injustice. Number 2, the Court of Appeal rules / Supreme Court rules. These rules allow parties to apply for 1. Stay of proceedings, 2. Injunction pending appeal, and 3. Stay of execution. Number 3, case law principles. Nigerian courts have held that they can halt lower court cases to prevent A. Abuse of court processes, B. Multiplicity of suits, C. Futile or wasted proceedings, D. Violation of constitutional rights. Leading authorities include Okafor versus Naife, Vaswani Trading Co. versus Savalak and Co. Ojukwu versus Governor of Lagos State. Now, when will a higher court halt a high court case? When will a higher court halt a high court case? A higher court, which is Supreme Court or Appeal Court, will entertain such an application if A. There is an appeal with arguable grounds. B. Continuing the high court case will cause irreversible injustice. C. There is a jurisdictional issue at stake. D. The lower court is acting in a way that may cause abuse of judicial process. E. A constitutional right is being threatened, which is the fair hearing and liberty. Now, what are the 5 possible steps the higher courts can take, which is the Supreme Court or the Appeal Court? Here are 5 actions the higher courts can take after an application is filed. 1. Grant a stay of proceedings. The higher court, which is the Supreme Court or the Appeal Court, can order the High Court to pause the case entirely until the appeal is heard or a legal question is settled. This is the most common step. Or number 2, they can grant an interlocutory injunction, which is the higher court can issue an injunction restraining the lower court, the judge, or the parties from taking further steps. This is stronger than a stay because it binds the parties directly. Now, number 3, it's call up the record / assume jurisdiction temporarily. The higher court, which is Supreme Court or Appeal Court, can order that the record of the case be transmitted immediately and suspend all proceedings in the High Court. This is used when a constitutional issue or jurisdiction question is raised. Number 4 step, it can dismiss the application and allow the High Court to continue also. If the higher court does not see merit in the request, it can dismiss the application and order the High Court to proceed without delay. And number 5, it can make consequential orders. The higher court may issue extra directives such as ordering accelerated hearing of the appeal, ordering the lower court to correct an irregular ruling, ordering parties to maintain the status quo, or warning the lower court against exceeding its jurisdiction. In this case, the higher court is the Supreme Court or the Appeal Court. Call them the higher court, while the lower court is the High Court. These are the 5 possible steps that we are expecting to be taken as regards Mazi Nnamdi Kanu's court case. Because as you are aware, Nnamdi Kanu knows the law more than many people. He has studied, he knows his rights, he knows the loopholes he has exploited, that he can exploit. And that is why you saw him throughout this past week. He has been moving from office to office, trying to see how he can, pass a message and also get a favorable, reaction from the higher courts. And of course, there is hope on the air because 20th is still many days to go. And we are expecting this coming week, we are entering now, to bring in new revelations. But definitely when you notice some, anomalies in your court, when you notice things are not actually going well the way you planned in a court, and It is not clear. Things are not going clear for you. Are you going to stand and watch while things unfold? Or are you going to take strong steps to make sure that, you fight for your own right? If there is one thing Nnamdi knows how to do very well, he knows how to fight for himself. He is not a man that believes in staying in one place while things rubbish him and spoil his name. He's not that kind of person. He was only respecting his lawyers. That was why he could not say a word throughout while they were representing him. Not because he doesn't know what to say, but because he wants to follow the process step by step. And it's got to a point he felt these people did not really understand my case, which is why I've always said that these sons, they never understood the emotional angle of Nnamdi Kanu's case. They were only interested in coming to court on that very day. I still believe they did not do their research very well, and they felt it's going to be one of all those cases they have done before. And thank God that right now, Nnamdi Kanu is holding his case by himself. So wherever you are around the world, let us have hope and believe that the coming days is going to be eventful. This is not time for you to feel down. It's not time for anyone to feel down. It's time for us to pick up ourselves and believe that the God that we serve will never disappoint us in this trying time. Because God shows up when the need is greatest, as always. And I will say this very clearly for you. Nigeria is not a country for the silent. Some people were asking, how did Nnamdi Kanu find his way to the Supreme Court or the Appeal Court? It's very clear. Some were saying, so the DSS allowed him to go there. So they even allowed him. Let me tell you something you don't know. Nnamdi Kanu presently is his own lawyer. And as his own lawyer now, he has the right to go to court to make filings for himself. Definitely, that's the privilege he has, being the lawyer of his case. So they have no right, they have no choice but to only escort him properly there. Because if they don't do that, it will be seen as obstructing justice. So they didn't do any favor to him. They just did their job to make sure that their hands are not there when their names are called. Definitely. And also, Nnamdi Kanu is not a person that keeps silent. Because like I told you, Nigeria is not a country for the silent. You can see what his silence almost cost him all these months. He allowed those quiet lawyers to handle his case, those sons. You can see what his silence almost cost his case throughout all these months. He was silent. But now he has taken over the case and is in the forefront of his case. You can see the progress that is being made so far. And I tell you, the coming days is going to be very, very eventful as we walk down the remaining days of this case, heading to 20th of November. I believe that with God, all things are possible. It is 4 days to the court case of Nnamdi Kanu, and we are believing for a miracle from the higher court. We are believing for the miracle from the CJN, from the Court of Appeal, to look into the case file of Nnamdi Kanu and strike out those irregularities that are omitted by Omotosho or committed by Omotosho. Of course, you know that the case being tried right now is under a repealed law, which, of course, according to the Constitution, is null and void. Nnamdi Kanu is asking for his case to be struck out. He's asking that the High Court does not have jurisdiction to try him. He's also asking to be discharged and acquitted, that this case does not hold any water because there is no prima facie case. These are very clear grounds for the higher courts to come now and take their decisions on this matter.